Now, away from that, the Federal High Court in Abuja has refused to grant former Kaduna State Governor Nasir El-Rufai bail in absentia. Justice Joyce Abdulmalik declined the application after counsel to El-Rufai, Oluwole Iyamu, moved the motion for bail to be heard. Earlier, the prosecution counsel, Oluwole Alade, while seeking an adjournment for arraignment, informed the court that the defendant is currently with the Independent Corrupt Practices and Other Relations Officers Commission and is not in custody of the Department of State Services. The court has now adjourned El-Rufai's arraignment to April 23rd. Now joining us, Osigwe Momoh is a lawyer who joins us now from Abuja to discuss this latest development. Osigwe, thank you so much for joining us. Now, legally speaking, can a court grant bail in absentia? And what does the refusal to grant El-Rufai bail without his physical appearance mean to his upcoming arraignment?
Thank you very much for having me here. Well, the answer is really not a yes or no answer. The short answer would be that if they have brought these proceedings under the Fundamental Right Enforcement Procedure, then yes, you can get bail in absentia. But that was not the process. They came with a regular criminal process and being defendant and asking for bail, whereas they have not been arraignment, whereas plea has not been taken. And so rightly, the court was not properly seized of jurisdiction over the matter to decide on the hearing of the bail at this moment. But it is my thinking that the next step they will do is probably to, bring the Fundamental Right Enforcement Procedure, asking for his bail at that matter.
Now, under the Nigerian law, must a defendant always be physically present before bail can be considered by the court? And with the arraignment now moved to April 23rd, what legal steps are likely to take place before the next court date?
Yes, the way it's worded is that a defendant must be physically present every day of his trial, and this is a criminal matter, so he has to be there. And so this matter, the court cannot hear this matter because the defendant is not here in a criminal trial. So typically matters are criminal and civil, but there are other procedures. One is a Fundamental Right Enforcement Procedure. That is his option. I think he's going to seek for bail under the Fundamental Right Enforcement Procedure. If he's coming with a criminal matter, as it is right now, as a defendant, he will have to, the court have to sit over the matter. But the fundamental rights, the criminal procedure in Nigeria contemplates daily trial. So, it ought to be very close, at least to the best of the court convenience. A matter in February taken into April is one of the problems we have in the judiciary. I understand the courts are overworked. It's a difficult process, but sometimes delaying justice is almost like denying it. This is quite a long time. And I'm thinking that we have to abridge the time, bring an application for urgency. We have these procedures and ask that, the matter should be heard earlier for bail. Otherwise, the next best thing they will do is to bring the Fundamental Rights Enforcement Procedure saying that this matter in its entirety is not worth the time of the court.
Right. And now, does the fact that El-Rufai is reportedly in ICPC custody affect the court's decision on bail and arraignment procedures?
Ordinarily, it ought not to be, but if the court is blinding his eyes from the reality, the court will say to himself that, well, this man is somebody that the security, the prosecutors are holding strongly, is a flight risk. Bail in Nigeria, there's nothing like an unbailable offense. Everybody deserves bail in Nigeria. It's just to the extent with which you can show the court that you will not either be a flight risk, tamper with the facts of the matter, you're not going to cause further crime when you're out there. So the court is going to wonder why, he's not been released on bail, and that may somehow think about. Most times, courts are blind until the matter is before them. Like in this case, the judge is saying, this matter is not before me. I'm probably not, taking the plea, so I can't decide on this matter one way or another. But when a defendant is being held in custody, you are almost telling the court that this is a difficult person, this is hard. If he leaves here, he may not come back. And it's kind of prejudicial, if you ask me.
All right, awesome. Thank you so much for your insight and your time on this matter.
My absolute pleasure.